I welcome you all to the Kigali International Forum conference, whose theme is After Genocide, Examining Legacy, Taking Responsibility. Shortly we'll be starting, but before then, a few announcements, please. It's a paperless conference. All the documents are on the website kwibuka.rw. There is simultaneous translation. Maybe I should have started with this. Channel 1 is for English, and channel 2 is French. We have free wireless connection. The conference is live streamed. You can also follow on Twitter, #Kwibuka20. All participants are invited to attend the welcome reception later today at Kigali Serena Hotel, 6:30, and the launch for the Upright Men project by Bruce Clark. And then there is also, all participants are invited to attend the Café Retrail at the Rwanda Revenue Authority Auditorium on Sunday at 4. More information is on the invitations. They are at the places where you're seated. You're also please requested for those that do not have your badges yet to collect them from Serena later today, as you'll need them for tomorrow. There is the final Flame Urumuri Rutazima tour on the 5th of April. All the participants here are invited to be part of that function. It's been touring all over the country in all the districts, so the final reception for it will be at Eto Kichuchiro. Organizers of the conference should be able to give you the details or also direct you how you'll get there. And finally, you're all invited for the 7th commemoration, which is on Monday. So shortly, our guest of honor will be arriving and we'll be ready to begin. I thank you. There is a book, The Path of the Genocide Perpetrated Against the Tutsi, by Dr. Bizimana. So a copy is given to each one of you. You're free to read and take it with you. Thank you. Okay. Okay. Okay.
What can you sort of sound? Of course.
The guest of honor, the Speaker of Parliament, will be entering shortly. Thank you. Our guest of honor has arrived, the Speaker of Parliament, accompanied by Her Excellency, the First Lady, Madame Jeannette Kagame, and the President of Senate. Thank you. Please take your seats. Your Excellency, the First Lady, Madame Jeannette Kagame, Honorable President of the Senate, Honorable Speaker of Parliament, Honorable Chief Justice, Honorable Members of Parliament, distinguished ladies and gentlemen. 20 years ago, Rwanda experienced one of the worst mass atrocities in modern history, the genocide against the Tutsi. This year, as we commemorate this 20th anniversary, we remember the lives that we lost, show solidarity with the survivors, and unite to ensure it never happens again. Madam Speaker, on behalf of the delegates, I want to thank you and the Parliament for hosting this international forum. The conference you are about to open forms part of the Kwibuka 20 program and was put together to examine issues of legacy, responsibility, international context, leadership after genocide, and nation building. Before us today are a number of distinguished delegates from all over the world. May I please request that you stand up for recognition when I call your country. Delegates from the United Kingdom, delegates from Germany, delegates from United States of America, from Belgium, from France, PAC members here with us today, PAC members, Ayala, delegates from Ghana, Kenya, and Uganda. So you're very, very welcome to this conference. Honorable Speaker, without further ado, It is now my humble duty to invite you to address the forum. Thank you.
Your Excellency, Madame Jeannette Kagame, First Lady, Honorable President of the Your Excellency, Madame Jeannette Kagame, First Lady, Honorable President of the Senate of Rwanda, Honorable Chief Justice, Honorable Ministers, Honorable Deputy Speakers of both chambers of the Parliament of Rwanda, Honorable Members of Parliament, Excellencies, High Commissioners and Ambassadors, members of the Diplomatic Corps, distinguished guests, ladies and gentlemen, on behalf of the Parliament of Rwanda, I am pleased to welcome all of you to this International Forum on Genocide. 2 decades ago, over 1 million Rwandans were murdered over the longest 100 days in our history. During commemoration, we honor the lives that we lost to the genocide. We offer solidarity and comfort to the survivors. We also pause to reflect on how far we have come as a nation and as a global community in ensuring that genocide never happens again. As you enter this building, you may have noticed the mortar and bullet holes on the walls. We have decided to leave them there to serve as a visible reminder of the scars we bear as a people and the duty we have to our children. Rwanda believes that citizens are at the center of government affairs. That is why Rwandans have been empowered to participate actively in the processes that determine their livelihoods. In this hall, we adopted a groundbreaking constitution designed with the input of thousands of Rwandans from all walks of life. After the genocide, the main challenges facing Rwanda were good governance, restorative justice, unity and reconciliation, the reintegration of survivors and returning refugees, and rebuilding the socio-economic fabric of the country. Our Constitution provides for mechanisms to achieve these objectives. Our economic policies have led to a drop of more than 12% in the poverty rate over the past 5 years, as the economy has grown at a rate of about 7%. We are on track to make Rwanda a middle-income country by 2020. We are now reaping the dividends of progress. What we take for granted today was unthinkable before 1994. The fact that the majority of our parliamentarians are women, nearly 2/3 of them, is a reflection of the ambition of the new Rwanda. The women of Rwanda are eager to play their role, and no one can stop them. All this has been possible because of determined, visionary leadership that promotes national unity, continuous dialogue, accountability, and the values of self-reliance. We can move forward more quickly because the 3 branches of government and civil society work together in harmony to rebuild the country. Our political orientation which takes inspiration from our history and culture, forms the foundation for our economic and social transformation. The implementation of Gacaca jurisdictions demonstrated the courage of Rwandans to confront our past with innovative solutions. Fighting the ideology of genocide as is at the core of our governance. We are united with a common purpose, one that values equality for all Rwandans, irrespective of faith, gender, social standing, or ethnicity. We have developed a national capacity to prevent genocide. This firm commitment is the basis of our strong motivation to participate in peacekeeping operations, especially in Africa. To entrench our achievements in unity and reconciliation, we recently launched a program known as Ndi Umunyarwanda to strengthen our common identity as Rwandans. Distinguished delegates, we as Rwandans are proud of our achievements, but we have a lot more to do. We recognize that the contemporary world is increasingly interdependent and connected. This is why we organized this forum and invited parliamentarians and scholars to come together to exchange views. We look forward to contributing to the prevention of genocide and genocide ideology around the world. I hope you will both bold and practical in your deliberation over the next 3 days. Once again, ikaze mu Rwanda. We thank you for joining us to mark the 20th commemoration of genocide against the Tutsi. It is now my pleasure to declare this forum open. Thank you very much for your kind attention.
Thank you, Madam Speaker, for the opening remarks. I'm called Mirema, and I was privileged to be your MC for the opening session. I now have the pleasure to hand it over to Mr. Tim Gallimore, who is the moderator for the next presentation, to please come over and also call the panelists that will go through, that will be part of this session. I thank you.
Good morning, ladies and gentlemen, diplomats, ministers, First Lady of the Republic of Rwanda. It's my pleasure to be here this morning to moderate this very first session in a very important event commemorating the 20th anniversary of those who were killed during the genocide in 1994. We have with us this morning a distinguished panel of 4 presenters and additional discussants who will talk about justice after genocide. Rwanda, as you know, has more experience prosecuting genocide crimes than any other country in the world. The national courts have prosecuted more than 4,000 cases so far, and the Gacaca jurisdiction has handled more than 2 million cases in the 10 years of its existence. The International Criminal Tribunal for Rwanda, the ICTR, has completed 72 cases of high-level perpetrators of the genocide against the Tutsi. There have been other prosecutions in national courts in Canada and in Europe, most notably recently in France. Today we'll hear from these panelists and discussants in the following order. The first presenter will be the Honorable Justice Johnston Busingye, who is Rwanda's Minister of Justice and Attorney General. His previous position was Principal Judge of the East African Court of Justice. He's also served Rwanda as President of the High Court, Permanent Secretary in the Ministry of Justice, member of the Law Reform Commission, and as a national prosecutor. He will be followed by Judge Von Johnson, President of the International Criminal Tribunal for Rwanda. Judge Johnson joined the tribunal in May of 2007 as an ad litem judge and member of Trial Chamber 3. He was elected as a judge of the International Residual Mechanism for Criminal Tribunals in December of 2011 and has served as duty judge in Arusha since July 2012. Before joining the tribunal, he was a judge with the Danish High Court for more than a decade and served as an international judge for the UN mission in Kosovo from 2001 to 2002. Judge Johnson served as a Danish Minister of Justice until he was appointed as a judge in the City Court of Copenhagen in 1982. He's also taught constitutional, criminal, and civil law at the University of Copenhagen. Judge Johnson will be followed by Dr. Andrew Wallace, who is a supervisor and research associate at the Faculty of Politics and International Relations, the University of Cambridge. He's a researcher, editor, and freelance journalist who specializes in Central and East Africa. He is the author of Silent Accomplice, The Untold Story of the Role of France in the Rwandan Genocide. He's currently researching political social history of justice issues as they relate to the genocide in 1994. The last panelist will be Mr. Alain Gauthier, who is president of Le Collectif des Partis Civils pour Rwanda, based in Reims, France. An expert on genocide trials in Europe, Mr. Gauthier and his wife Dafrosa have tracked down more than 25 genocide fugitives who have been hiding in France. Using their own resources, the couple has traveled between France and Rwanda for 20 years, gathering evidence from witnesses and documents for the Partis Civils to prepare cases against perpetrators of the genocide. The recent conviction of Pascal Simbikangwa is largely the result of their work. Their efforts for justice have been compared to the famous Nazi hunters Wiesenthal and Carlsfeld. Mr. Gauthier is a retired school teacher. As a young seminarian, he also taught French at the Petit Séminaire de Save near Butari from 1970 to 1972. So our first presenter will be Honorable Justice Johnston Busingye.
Thank you, Tim. Good morning, ladies and gentlemen, Your Excellency, First Lady, Honorable Speaker, Honorable President of the Senate, Honorable Speaker, ladies and gentlemen, all protocols observed. I was asked to speak about the role of the courts in this conference. But I'm the first panelist. I don't know why. I thought the first one should have been someone who would talk about the history. But let me try to give you, in the few minutes that I have, a little background about the court system in this country. But let me say this, that the genocide that we will commemorate 20 years for the 20th time this week happened because the state did the opposite of what states do. Instead of fostering harmony and rule of law and coexistence, it allowed and supported an ideology and a collective thought and action process that was capable of only one ending: mass atrocity. So when we talk about the genocide that happened in this country in 1994, we need to look at it in the context of the thought and action process that preceded it 30 years before. By 1994, if you assaulted a Tutsi person in Rwanda, if you killed a Tutsi person in Rwanda, it was not as much a crime as killing a cow or assaulting a cow. And that is what a thought and process that is fundamentally flawed will lead you. You will only have one conclusion, and that will be mass atrocity. In our case, it was the extreme genocide. In the aftermath of the genocide, our institutions, including the justice system, were destroyed. Those of you who are here know what we went through to try and bring sense, a little bit of sense, to the court system. Our judges, our prosecutors, our investigators, our infrastructure, anything you could talk about taking you to the semblance of justice was completely destroyed. The legislation we had was not only in need of serious modification even before the genocide, but it was totally, it couldn't support the situation we were in immediately after the genocide. The pressure that we had from not only the numbers of prisoners we had in our prisons, but also the international community to do justice and to do it like yesterday, those pressures were always on, and we had to deal with them and manage them the best we can. And the responses were not as much. In fact, the choices were very few, very limited choices. Did we want to train people and be sure that we have enough judges, enough prosecutors, enough investigators to handle the matters? Did we have enough legislation? Therefore, we needed to work on laws that would help us to address the situation. What choices did we have? Secondly, even if we did have the choices, what was the magnitude of the problem that we had? What if the court system, what if the judicial system survived the genocide? What if after the genocide all the judges and courts and so on were intact? Certain times we overlook this question and think that maybe the responses we had, Gacaca and the other responses, were because the justice system had collapsed. But what if it had survived? My contention, ladies and gentlemen, is that even if the court system had survived, it was ill-equipped, it was not the system that could address the complexities of the post-genocide Rwanda. Classic justice was going to have terrible issues of dealing with a divided society, a ruptured society, whichever way you looked at it. A case in point, is, I'm sure the president of the ICTR will tell us about what the ICTR has contributed in this area. But if you count in terms of numbers, we would still be waiting probably not the 200 years that we were counting in 1994, but if we went by that system, we would probably count 400 to 500 years. And we also had issues of reconciliation, and we had issues of truth, and we had issues of citizens who had borne the brunt of that thought and action process for 50 years plus, and were still alive, and they had lost their dear ones. So what did we want to do is a major issue that probably this conference will look at. And what has it left for us? My contention, ladies and gentlemen, is that the classic courts, even if they had survived the genocide intact, they would not have addressed the issues of truth, the issues of reconciliation, the issues of impunity, and the issues of getting back a nation, salvaging a nation. We were a nation that was called unviable by the best of research economists, that was written off by all politicians in the world. And what you needed in terms of human beings, in terms of bringing sense to our communities, in terms of people getting to live together, certainly was not the classic courts. My experience with the classic courts is about winning and losing. In 1994, our problem was not basically who wins and who loses, full stop. It was never going to resolve the problems that we had in this country. And even after transforming legislation, even after removing the death penalty, you still find more issues that the classic court system would certainly never have dealt with sufficiently. But let's for a moment look at when we still had the death penalty. Many times we discuss these issues and ask ourselves, punishment for genocide in the classic courts would have been, if you are found guilty, probably you would be sentenced to death. And many times I have asked colleagues, if you became a president of this country and you have 10,000 or 20,000 or 30,000 death warrants to sign, how many of you would sign them? How many? Secondly, what if you did? What would you get after this? I'm sure you would get a more divided society. I'm sure you would get a more ruptured society. I'm sure you would get a more decimated society. And so what Rwanda chose, which I think will be addressed by my other colleagues, what Rwanda chose was a result of conscious examination of its situation. And Gacaca, I want to say, was not simply a failure of other systems. It was a response to the complex issues that the genocide left to us. My final point is, was Gacaca perfect? I have read many places Gacaca has left mixed legacy, Gacaca wasn't this, Gacaca was not that. I also think that Gacaca was not perfect. But I also have another question. Now that we have international people here, our friends researchers, academics, which system is perfect? I want to put this question on the floor. Perhaps we'll have to discuss it at some point. Which system is perfect? And which system was perfect to address the issues of Gacaca, that Gacaca addressed? My contention, ladies and gentlemen, is that Gacaca delivered on its objectives. And if you ask me by how much, I will tell you by as much as Rwandans needed to move on. I thank you.
Ladies and gentlemen, I want to remind you that as the speakers give their presentations, you may make note of your questions or comment that you'll make during the open time of discussion, because we will continue one panelist after the other, but there will be time for you to address some of the issues and ask your questions. Next presenter is President of the ICTR, Honorable Justice Johnson.
Your Excellency, First Lady, Madame Gacaca, Honorable Speaker, Honorable President of the Senate, Honorable Excellencies, invited guests, panelists, and fellow panelists and discussants, ladies and gentlemen, good morning. I'm honored to share this platform with such distinguished individuals and to have the opportunity to briefly address the legacy of genocide justice. I would like to thank the Rwandan Parliament and the organizers of the Kigali International Forum for inviting me to be a part of the discussions taking place over the next 3 days as we examine legacy and responsibility after genocide. I would also like to thank Rwanda for allowing us, the international community, to take part in this historic commemoration. I'm humbled by the enormity of this event. Taking part in the commemoration of the 20th anniversary of a genocide provides an excellent opportunity for reflection. This is a somber time as we rightfully commemorate all of the victims of the atrocities that took place throughout Rwanda in 1994. But it is also a time for positive reflection as we examine how far Rwanda has come since those 100 dark days. There can be no question of the leaps this country has taken in the past 20 years, or of the milestones that have been achieved along the way. Nor can there be any question that it has been an astonishing thing to witness the resilience of the Rwandan people. Committing to reconciliation and justice at the same time is no easy task, but Rwanda has remained devoted even as adversity continually tests both sides of this task. I'm a judge in an institution created by the UN Security Council to contribute to the process of national reconciliation by prosecuting those responsible for serious violations of international humanitarian law. It is important to note the distinction made by the Security Council in this regard, contributing to reconciliation through criminal prosecutions. Creating accountability mechanisms is only one facet of the healing process. And I think by now it is all too clear to anybody who has studied justice mechanisms following atrocity crimes that the traditional retributive approach focused on prosecution cannot on its own bring about reconciliation. The concept of justice must therefore extend to include assistance, protection, security, and prevention, and, as Madam Speaker said in her opening remarks, the creation of a society that offers equal opportunities to individuals irrespective of ethnicity, beliefs, and other background. Rwanda has been at the forefront in all of these areas. As the theme of this panel is the effectiveness of genocide justice mechanisms, I think a critical question to consider at the outset is why we have international tribunals in the first place. Consider this question in the Rwandan context. By November 1994, most Rwandan judges and lawyers had been killed or had fled the country. The new government had to rebuild the country and its institutions, an endeavor that included the prosecutions of hundreds of thousands of alleged perpetrators at various levels who were accused of committing crimes related to the genocide. During the intervening and formative years of the Gacaca efforts, and while the country was focused on rebuilding its national courts, Rwanda's newly formed government was simply incapable of tracking, arresting, and trying some of the highest-ranking former military and government leaders and other high-profile fugitives who had fled the country in the wake of the genocide. Thus, the International Tribunal is a creature of necessity. Where there are gross violations of international law and legal proceedings in national courts are unattainable, or there is evidence of unwillingness to prosecute, the International Tribunal represents the promise of accountability and justice. This is, of course, based upon the idea that an international tribunal will have institutional capacity, investigatory wherewithal, state cooperation in investigating and arresting suspects, and impartiality. The ICTY and the ICTR have had an unmistakable impact on the evolution of international criminal law, which has in turn had an impact on the rule of law in Rwanda throughout the Great Lakes region and beyond. In that regard, I would now like to discuss the role played by the ICTR and ICTY in the development and future of international criminal justice in the wake of genocide. From the beginning, in the fulfillment of their mandate, the ICTY and the ICTR crystallized international legal concepts and provided a model for domestic judiciaries to follow. In the early judgments, the tribunals codified numerous facets of international criminal law and international humanitarian law that were at that time undeveloped, not the least of which are findings made with respect to charging rape as genocide. The ICTY Kuranach judgment was the first case in the history of international criminal law to convict solely on the ground of sexual violence, while the ICTR Akayesu judgment was the first conviction for rape and sexual violence as a form of genocide, and the first time that an international court interpreted and applied the definitions of rape and sexual violence in international law. The Akayesu judgment recognized that, quote, sexual violence was a step in the process of destruction of the Tutsi group, destruction of the spirit, of the will to live, and of life itself, end quote. In doing so, it paved the way for a number of convictions for rape as a method of genocide, including in the Gachum Bitisi, Muhimana, Musimena, Rukundu, and Rensaho cases. In addition, the conviction of Pauline Nwamesahuku for her role in ordering the rapes of Tutsi women and girls demonstrated that the perpetrators of sexual violence, like the victims, are not limited to either gender. For my part, I was a member of the trial chamber which heard the Karamera case, and in the trial chamber we considered rape to have been a natural and foreseeable consequence of the genocide campaign. This marked the first time men were convicted under the extended form of joint criminal enterprise, also called JCE, for acts committed by others which were a natural and foreseeable consequence of the greater JCE plan. Though this is a concept that was first introduced in the ICTY Tadic case in 1999, the Karamera trial judgment was the first application of this concept to rape, and it remains to be seen whether it will stand on appeal. The legacy of the ICTR with respect to sexual violence, however, extends beyond these contributions to the jurisprudence. In particular, through the work of the prosecutor, the ICTR has amassed a wealth of institutional knowledge about the unique challenges posed by the investigation and prosecution of sexual violence crimes in the context of mass atrocities. These challenges included investigating crimes that typically involve multiple crime scenes, substantial evidence, and large numbers of suspects, victims, and witnesses. The prosecutor also confronted the dual challenge of gathering evidence, not only to establish that sexual violence occurred, but also the guilt of high-level accused, who often were not present at the scenes of the crimes they organized or accepted. The lessons learned by prosecuting these crimes have been integral to structuring outreach and capacity building initiatives and shaping future prosecutions in domestic courts, especially with respect to sexual violence. On this note, Prosecutor Jallo and his staff deserve praise for actively sharing best practices, including the recent publication of the Best Practices Manual on the prosecution of sexual and gender-based violence in conflict and post-conflict areas. Innovatively, this manual considered discussions with experienced prosecutors in international and domestic jurisdictions, as well as input from victims of sexual violence. Having attended some of the prosecutors' workshops in the final stages of the development of this manual, I've seen that the prosecutors in the Great Lakes region are trailblazing in their efforts to improve prosecutions for crime of sexual and gender-based violence. And Rwanda in particular has, since the early days of post-conflict reconstruction, prioritized sexual violence crimes, as evidenced by prioritizing the commission of sexual torture to Category 1 of offenses under the genocide laws. It has not only been in the area of sexual violence that the tribunal has focused its efforts on outreach and capacity building, however. In order to ensure that the affected communities understand the work of the tribunal, the ramification of the genocide, and lessons learned in our battle against impunity, many of the outreach programs focus on education through mass media. I believe this is an important step in keeping with the concept that justice mechanisms, whether internationally or domestically organized, must not only do justice, but must also be seen to be doing justice by the people affected. In the same vein, the ICTR has developed legal standards for the referral of cases to domestic jurisdictions. These referrals serve as a precursor, albeit a concurrent one due to the timing of the application, to the complementarity principle of the Rome Statute, which limits the International Criminal Court, the ICC, to investigating and prosecuting core international crimes only when national jurisdictions are genuinely unable or unwilling to do so. With the recent referrals of the ICTR's Uwinkindi and Munyagishari cases to Rwanda, as well as several others from other national jurisdictions, the carefully crafted and ever-evolving transfer laws that Rwanda has enacted are being put to the test and are proving that a judiciary destroyed by conflict can be rebuilt and can handle adjudication of the crimes that led to the destruction of that very system. We are also already seeing Rwanda's transfer laws serving as an example for other countries in its attempt to handle domestically matters that previously would have been dealt with by an international or internationalized court. The UN Security Council has repeatedly stressed the need for international cooperation to strengthen domestic infrastructure and involve more national judiciaries in conflict resolution and peace processes. In strengthening the capacity for domestic courts to try those accused of international crimes, we naturally enhance the capacity to fill the immense void which is currently only partially filled by the ICC. Thus, complementarity, whereby the ICC relies on national and regional courts to try those they can and refer those they cannot, is the real future of international justice, in my opinion. I hope to see international justice mechanisms following the complementarity approach and the future expansion of national jurisdictions over war crimes, crimes against humanity, and genocide. Sadly, however, with peace in a state of disarray in many parts of the world, it is possible that ad hoc tribunal or hybrid tribunals may be required in the future. It is my sincere hope that the ICTR has provided guidance should there be any further need for international tribunals, but much more can and should be done. Prosecution alone is insufficient to serve the goal of reconciliation in a post-conflict society. Therefore, serious efforts to strengthen the rule of law domestically and promote local capacity building is the only lasting means of ensuring lasting peace, stability, and observance of international humanitarian law, especially in countries that have been ravaged by mass atrocity and conflict. As Kofi Annan stated in his Enlarger Freedom report, quote, "We will not enjoy development without security, and we will not enjoy security without development," end quote. In this respect, the overall impact of the ICTR and other international courts will depend on their ability to transfer best practices, lessons learned, and sound legal frameworks to the domestic criminal judiciaries and move towards transitional justice. I'm honored to be a part of the legacy of the ad hoc tribunals and the contributions these tribunals have made to international criminal justice. I look forward to further discussions by the esteemed panel members and discussions on some of the topics I've addressed today, and wish to thank you all once again for inviting me to participate in this historic conference. Thank you.
Thank you, Justice Johnson, for your presentation, and I'm sure there are plenty of questions that the audience has in response to your remarks and the general knowledge of the tribunal and its efforts over the last 20 years, and I'm sure that we'll get some of that started now by Dr. Wallace's presentation. And I'm told that we need to change our format a little bit because we're not supposed to be so formal in giving speeches, so we have this microphone. But as you are listening to the presentations and jotting down your questions, I know that there are so many issues about transitional justice that we've not touched on yet, including the contribution to reconciliation in the country, issues of compensation, of truth-telling, and so forth. And I think Dr. Wallace might start on those issues, but we indeed really want to engage you with that, so I put that on the table to start with. And now, Dr. Wallace.
May I begin with a big vote of thanks for actually being allowed to address such a wonderful gathering. And may I also begin with a shameless advert for a documentary that we've made in the past year to be shown on Al Jazeera on next Wednesday, in fact. My bon ami, Monsieur Gautier here, for the last year has allowed us to follow him around with a camera as he has done his wonderful work, which culminated with the trial in Paris. The documentary is called Justice Seekers on Al Jazeera next week. And you can see Alain at home doing his shopping, as well as some stunning work in the legal field. During the past 6 weeks, I've sat at trials, appeal judgments, and hearings of genocide suspects in London, Kigali, Paris, and Arusha. It has been a salutary and not wholly pleasant experience that has left me with the undoubted feeling that, to paraphrase my national bard Shakespeare, there is something rotten in the state of international justice. So I want to throw out some possibly controversial questions which seem in immediate need of answers, especially by Western countries. If justice is not to become purely a pawn of politics, finance, and highly subjective legal interpretations that may suit the legal fields among us, but not justice itself. So there seems to be an unwritten rule, and it goes like this. If horrific crimes, and let's say here genocide, extermination, or crimes against humanity, take place in Africa or developing countries, then the West will come along and take care of the subsequent justice. It will set up international courts or tribunals, or possibly, when it gets round to it, it will try those responsible in its own much praised developed justice systems. Yet, if such terrible crimes or outrages take place against or in such a Western country, then the unwritten rule says the alleged culprits will not go to an international court or tribunal. Instead, the authors of 9/11, of attacks against Western troops in Iraq or Afghanistan, can expect far more summary justice in the form of a rather speedier method. For example, remotely piloted aerial systems, as the Ministry of Defence in the UK calls them. That's drones to you and I. Can anyone here seriously imagine Saddam Hussein, Bin Laden or Gaddafi being put in an international court, spending 10, 15 years going through trial and appeal, and then receiving a 15-year sentence? And that being, of course, maybe downplayed on appeal, and him being released anyway for having served 2/3 of his sentence. 2,000 years ago, Thucydides wrote that the standard of justice depends on the equality of power to compel, and that in fact the strong do what they have the power to do, and the weak accept what they have to accept. Notwithstanding what we've just heard from the president of the ICTR, it strikes me that the ICTR, having spent far too long there in recent years, has begun to founder rather badly. It was set up in late '94 following a wave of mostly American guilt at the failure of the global failure to halt the genocide. It has been plagued by a host of less than flattering allegations throughout its life: financial mismanagement, political interference, indifference to witnesses, evident failures by the prosecution to provide coherent indictments and trial strategy, and that is to name but a few. In addition, several of its appeal bench rulings since 2008, which have overturned hefty trial sentences to acquit the accused, have caused intense controversy. In a growing number of cases, critics accuse the office of the prosecutor of failing to complete basic tasks. The appeal bench has declared initial indictments constantly to be in error in numerous judgments. The recent Diliamana military coup judgment was yet another highly embarrassing setback for the office of the prosecutor. How survivors, and indeed UN taxpayers, are entitled to ask, after tens of millions of dollars spent investigating and prosecuting cases, can such fundamental errors be made time and time again? Second, then, there is the enigma of the 83-year-old American judge Theodore Meron, the president of the appeal chamber and residual mechanism, charged with the all-important legacy of the ICTR and also the ICTY in The Hague. As we know, a growing number of leading military and political leaders found guilty at original trials in The Hague and Arusha have walked free after Meron's appeal bench has overturned, often on a split decision, the initial verdicts. At the ICTY in The Hague, Meron has presided over an appeal bench that dismissed long trial sentences against 2 senior Croatian generals, split 3-2 decision, and the Serbian commander Momcilo Perišić. These judgments were used as precedents to later free 2 Serbian secret police chiefs accused of war crimes. In his dissenting opinion, after another split decision in this later case, Judge Pickard noted, "If we cannot find that the accused aided and abetted these crimes, I would say that we have come to a dark place in international law indeed. He condemned the precedent-setting interpretation of aiding and abetting as overly restrictive, raising the bar for proof so high that a guilty verdict was virtually unobtainable. At the ICTR, Judge Liu Duquin dissented from Meron's majority verdict in the appeal of Justin McGenzie, also freed after a long initial trial sentence. Judge Liu noted that, notwithstanding this detailed and considered evaluation of the evidence by the original trial judges, and without identifying any specific error, this conclusion of the appeal bench judges is without foundation and exceeds the purview of the appeal chamber. However, in January this year, the ICTY's appeal chamber released an 800-page judgment that affirmed guilty verdicts on Serbian commanders for crimes in Kosovo. In doing so, they decided that the appeal judgment in 2013 in the Perisic's release was in error. In effect, to laymen, that means the two appeal chambers are now in disagreement with each other over legal interpretation. As a result of this decision, the ICTY prosecutor took the quite extraordinary step in February this year of appealing Meron's appeal chamber decision that acquitted Perisic. So, as the judges at the ICTY descend into an undignified and quite bewildering internal wrangle over legal interpretation, the prosecution team at the ICTR was sitting in shock as Meron's appeal bench overturned 3 more trial verdicts in February this year. Members of the OTP later expressed despair to me that given the way cases were now being decided by the appeal judges, the dozen or so remaining appellants at ICTR could all reasonably expect to be freed. First among them could well be General Augustin Bizimungu, originally sentenced to 30 years. As damaging as the legal wrangling and case decisions have been, another internal controversy has brewed following last year the release of an internal email from appeal judge Frederick Harhoff that accused Meron of following an American-Israeli agenda that meant decisions were watered down when they impinged on the highly debatable legal interpretation around command responsibility, thus precluding any future legal action against United States or Israeli senior officers or politicians as a result of military action, say, in Iraq, Afghanistan or Gaza. Harhoff's leaked email argued that Meron's interpretation made it almost impossible for any political or military leader to be ever held accountable unless they were actually at the crime scene giving the orders. Harhoff was subsequently sacked from the ICTY appeal bench. Whatever the rights or wrongs of Meron's interpretation and his motivation, and there's been much argument on this, the end result is clear. It has brought further confusion, controversy and disrepute to the International Judicial Tribunal system. The guilt or innocence of the accused has seemingly become of secondary importance to legal interpretation and realpolitik. Third, briefly, there are efforts, obviously, by individual states to bring belated justice to those accused of the genocide, and these too have run into difficulty. Western justice has been exceptionally slow to bring before its courts to face extradition or trial under universal jurisdiction those accused of Category 1, key organisers and planners of the genocide. Alain here, I think, will be talking about the role of France. Last week I was at Westminster Magistrates Court in the UK, where the Crown Prosecution Service, acting for the Rwandan government, is seeking to get a positive verdict to extradite 5 suspects accused of genocide. Such cases in Western judicial systems throw up a host of issues. They include, of course, the political and financial will for the cases to go ahead in the first place, when each trial or hearing can last months or years. Witnesses, many needing protection or added security, need to be flown thousands of miles or give evidence by video link. Both prosecution and defence lawyers must travel thousands of miles to the crime scene to carry out their own investigations. Expert witnesses in the UK are used in the dock more as a means to express their own political views on the current government here, or to engage in genocide denial, rather than to offer the judges any real help. Court staff themselves struggle over locating crime scenes on maps in a country they've never been to, argue about specific customs and Rwandan cultural norms, totally alien to them. The experience of seeing court officials in London last week trying to understand complex Kinyarwanda phrases has to be heard to be believed. So in conclusion, international justice has reached a crossroads. And to me, at present, it too finds itself in the dock. Victims and survivors are at the very root of international justice, yet they are also forgotten amid all the legal and political disputes. How do you explain to them why a politician or military chief who gave orders for their family or village to be destroyed is guilty, according to one judge, but then released by another because of fears about how command responsibility may impact on their own leaders back in the West? Or that for political reasons there can be no extradition, nor will the accused face justice in their new Western home for financial reasons. States that back the concept of international justice, but not its implementation, cannot be surprised when they are accused of wholesale hypocrisy. Meron himself, in one of his very few interviews, accepted that international justice was indeed selective in a situation where justice was imposed on the weak, but never applied to the strong. The appeal bench president noted that achieving a few prosecutions was better than none at all, which would be the case if the courts, the tribunal, did not exist. The difficulty is that such selective prosecutions, together with selective decisions inside the courts, based on highly controversial legal interpretation, make the prospect for an end to impunity for war crimes and genocide seem a long, long way off. While much is made of the never again mantra when it comes to genocide, perhaps more should be made of never again when it comes to failures to bring those responsible to justice.
Thank you, Dr. Wallace, for your presentation. And now we've heard some of the issues starting to surface about mixture of politics and genocide justice, even accusations of bias on the part of judges, double standards in legal rulings, and of course the fact that justice is far away from the intended beneficiaries of the various tribunals. So we'll take our last presentation and then questions from you and comments from some of our discussants. Mr. Gauthier. Je crois qu'il va faire son intervention en français.
Muroneza, I should like to speak in English. Tiangwa et Kinyarwanda, Rico, I think I'm better in French. So, thank you very much. Je voudrais d'abord ne pas remercier Andrew, qui m'a mis un petit peu la pression, parce que j'ai vu qu'il était lui-même impressionné. J'ai vu ses feuilles, ses notes qui tremblaient beaucoup. À moins que ce soit Tim qui nous ait tendu un piège en nous laissant assis et tenir le micro. Mais bon, on va faire comme ça. Donc j'interviens ici, je ne suis ni universitaire, ni chercheur, ni spécialiste de de la justice, simplement un citoyen franco-rwandais qui un jour a pris conscience dans son existence eh bien, que la présence des présumés génocidaires rwandais qui étaient en France nous était insupportable et était insupportable pour les victimes du génocide des Tutsis au Rwanda. Et donc en 2001, nous avons initié avec des amis, mais je dois y associer ici Dafrosa, mon épouse, sans laquelle évidemment ce travail n'aurait pas pu se faire. Donc nous avons créé une association qu'on a appelé le collectif des parties civiles pour le Rwanda. Et nous nous sommes donnés comme objectif quasi unique de faire poursuivre en justice les présumés génocidaires rwandais qui étaient en France, et Dieu sait s'ils sont nombreux. Nous avons aussi dans notre association une petite partie, je dirais, humanitaire, qui nous a permis d'aider en particulier les rescapés et les victimes du génocide à Gisagara, dans l'affaire Dominique Naokuliayo. Dominique Naokuliayo étant sous-préfet de Gisagara et qui a été jugé finalement par le TPIR et condamné par le TPIR, mais nous nous étions aussi engagés à aider ces rescapés là-bas de Gisagara. Je ne peux pas m'empêcher dans la mesure où j'ai très peu de temps, donc ce n'est pas en 10 minutes que je vais pouvoir vous présenter le travail du collectif des parties civiles. Simplement, je voudrais commencer par l'événement qui s'est produit en France il y a 2 semaines, qui est la condamnation pour crime de génocide, pour la première fois en France, condamnation pour crime de génocide et complicité de crimes contre l'humanité d'un ex-membre de la garde présidentielle, vous le connaissez tous bien sûr, Pascal Simbikongwa. Pascal Simbikongwa, c'est donc le premier procès qui a été initié en France dans le cadre du génocide des Tutsis. Et je dois dire que c'est un procès qui a été d'une haute tenue. Bien sûr, ça a été un procès extrêmement difficile. 6 longues semaines, physiquement, psychologiquement, j'avoue que ça a été très éreintant. Mais je voudrais insister sur les raisons pour lesquelles ce procès a été historique. Tout d'abord, je dois souligner ici la qualité des membres du jury et des juges dans ce procès. Le président de la cour d'assises a été exemplaire. Il connaissait le dossier sur le bout des doigts. Il a pu donner la parole d'une façon très équitable aux parties civiles, à l'accusation, à la défense, pardon. L'avocat général a été aussi d'une très grande exemplarité. Sans parler des jurés, ce sont des jurés, vous savez que ce sont des jurés d'assises, ce sont des citoyens français qui ont été plongés en 6 semaines dans ce génocide des Tutsis. Et en 6 semaines, il a fallu qu'ils revivent, grâce aux témoins, le génocide. Remercier aussi les avocats des parties civiles. Le collectif des parties civiles était bien sûr le fer de lance de ce procès, dans la mesure où nous avions découvert Pascal Simbikongwa à Mayotte, où il était réfugié, et c'est le collectif des parties civiles qui en 2009 avait déposé plainte contre lui, ce qui a permis qu'il soit poursuivi en France. Je dois également remercier, puisque j'en suis au remerciement, tous les témoins qui ont participé à ce procès, en particulier les témoins qui sont venus du Rwanda, qui souvent étaient de simples citoyens, des Batulagués comme on dit, et qui ont été d'une dignité exemplaire. En particulier, lorsque les avocats de la défense ont cherché de manière parfois méprisante à les déstabiliser. Et ils ont été d'une extrême force, et sans eux, bien évidemment, nous n'aurions pas gagné ce procès. Donc ce procès est historique, surtout par son verdict, parce que c'était un procès extrêmement difficile, un procès sans victime désignées, nommées, et donc nous pouvions craindre le pire. Et heureusement, les jurés et les 3 juges professionnels se sont rangés derrière l'avis de l'avocat général, qui en cours de procès avait requalifié non pas, la complicité de crimes de génocide en crime de génocide. Et les jurés ont suivi cette nouvelle qualification. Bien évidemment, nous avons été très satisfaits de ce verdict. D'aucuns diront que 25 ans de prison, c'est peu. Oui, c'est peu, mais nous avions décidé à l'avance de ne pas tenir compte de la peine qui serait infligée. Je pense qu'il n'y a pas de peine qui corresponde à un crime de génocide. Donc nous acceptons les 25 ans de prison. Malheureusement, Pascal Sibi-Kangwa fait appel et d'ici quelques mois, nous devrons recommencer ce procès avec un autre président, un autre avocat général et d'autres jurés. Vous savez qu'en France, donc, les choses ont beaucoup évolué. Pendant 17 ans, pratiquement, la justice française a traîné les pieds. Vous en connaissez les raisons, je ne suis pas là pour les développer, ce n'est pas le sujet de mon intervention. Il y a eu bien sûr des freins politiques, je ne fais simplement que les évoquer, mais il y a eu un tournant dans l'histoire de la justice française, c'est la création, en janvier 2012, d'un pôle crime contre l'humanité au tribunal de grande instance de Paris. Et à partir de ce jour-là, 3 juges d'instruction à temps plein ont été nommés, aidés par une dizaine de gendarmes, tous ces gens-là viennent régulièrement aujourd'hui au Rwanda en commission rogatoire. C'était un passage obligé. Et chaque fois qu'ils viennent pour enquêter sur 4, 5, 6 dossiers en même temps, en se répartissant les tâches et en se répartissant à travers le Rwanda. Ce procès de Pascal Sibi-Kangwa, bien sûr, nous espérons, va ouvrir la route à de nombreux autres procès. Vous savez que le collectif des parties civiles, depuis sa création en 2012, a déposé déjà 19 plaintes contre des présumés génocidaires. Nous en préparons 4 autres. Donc, il y a bien évidemment un encombrement sur le bureau des juges d'instruction. Mais nous ne pouvons pas nous résoudre à cesser le combat tant que nous saurons qu'il y aura des présumés génocidaires en France qui ne seront pas poursuivis. Normalement, le prochain procès, si les juges d'instruction décident de les déférer en cour d'assises, le prochain procès devrait être celui de Octavien Guinzi et Tito Baraira, tous deux anciens bourgmestres de Kabarondo, dans l'ancienne préfecture de Kibungo. Octavien Guinzi, c'est nous-mêmes qui l'avons fait arrêter aussi à Mayotte, où il se cachait. Il est en détention provisoire depuis 4 ans. Vous savez qu'en France, la détention provisoire ne peut pas dépasser les 4 ans. Donc, à la fin du mois, normalement, les juges d'instruction devraient annoncer la clôture de l'instruction et donner leur décision, soit déclarer un non-lieu, ce que nous ne croyons pas, soit le déférer avec son compère Tito Baraira, qui l'avait précédé comme bourgmestre de Kabarondo, donc de les déférer en cour d'assises. Et je pense que ce devraient être les prochains procès début de l'année prochaine. Et puis, vous avez su que tout récemment aussi a été arrêté dans le nord de la France un médecin, c'est le 3e que nous poursuivons en justice, après le docteur Sosten Monyemana et Eugène Rguamutio, qui étaient tous deux à Butare. Un 3e médecin a été arrêté la semaine dernière. Il s'agit de Charles Touagira. Charles Touagira que nous poursuivons en justice. Nous avons déposé plainte contre lui en 2009. Il avait perdu son travail à l'hôpital de Rouen. Il en avait retrouvé un autre dans un autre petit hôpital de province, à l'hôpital de Vire, en Normandie, où je l'avais personnellement repéré l'année dernière. Et il a été arrêté il y a 2 semaines et maintenu en détention provisoire. Je ne connais pas l'issue de cette arrestation. Et puis j'ai parlé de 19 plaintes déposées par le CPCR, mais au total, nous nous sommes associés à d'autres plaintes qui étaient antérieures, dont la plus ancienne était celle contre l'abbé Wenceslas Monyechaka, qui date de 1995 et qui avait été déposée par d'autres associations, ainsi que donc le docteur Sosten Monyemana, Laurent Boutibaruta, Laurent Seloubuga, Cyprien Kayondo et Fabien Neretse. C'était les 6 plaintes qui existaient avant la création du collectif. Fabien Neretse a été extradé vers la Belgique où il est aussi poursuivi. Cyprien Kayumba, qui lui était chargé de chercher de l'argent pour le génocide, lui est toujours en France, mais Actuellement, nous n'avons pas les moyens de faire des recherches sur son cas et c'est une plainte que je dirais dormante. Laurent Seloubuga, vous avez su qu'il avait été arrêté l'année dernière. Nous avons réactivé la plainte contre lui. Nous ne savons pas le sort qui sera fait non plus. Et puis les deux autres, l'abbé Gacaca et Laurent Bouti-Balouta, vous savez que ce sont deux dossiers que le TPIR traitait lui-même aussi. Et le tribunal pénal international a demandé à la France de les juger. La France a été condamnée en 2004 pour retard apporté à rendre la justice dans l'affaire Gacaca. Ça fait 10 ans et Gacaca n'est toujours pas jugé. Nous espérons, on nous a promis que si procès il y a, ce pourrait être fin 2015, début 2016. Et puis, je me permettrai simplement, parce que je ne peux pas citer tous les présumés génocidaires que nous poursuivons, simplement comme ça pour rappel quelques noms. Donc j'ai parlé de Laurent Seloubuga, l'ancien chef d'état-major adjoint des phares. Il y a aussi Calix Mbarushimana, qui était le secrétaire exécutif des FDLR, que, à notre grand étonnement, la CPI n'a pas voulu condamner ni juger. Un fondateur des FDLR, Rafiki Hyacinthe Nsengiyumva, contre lequel nous avons aussi déposé plainte. Et puis, bien évidemment, Madame Agathe Abiyalimana Kanziga, qui est, je dirais, la plus célèbre des sans-papiers en France, puisque le Conseil d'État, l'instance suprême, lui a refusé un titre de séjour tout récemment, enfin à la fin de l'année dernière, et elle vient de faire appel à la Cour européenne des droits de l'homme pour obtenir je ne sais pas quoi. Maintenant, la France n'a jamais pris aucune décision concernant cette affaire. Je sais que c'est une affaire qui embête tout le monde. Là aussi, nous attendons. En tout cas, pour en savoir plus sur toutes les personnes que nous poursuivons, eh bien, il suffit de se reporter au site du collectif des parties civiles. Vous avez là tous les éléments qu'il faut. Vous avez pu suivre d'ailleurs sur ce site, pour ceux qui ont pu et qui ont voulu, vous avez pu suivre, puisque tous les soirs, je faisais un compte-rendu des audiences auxquelles j'assistais, puisque j'ai assisté personnellement à toutes les audiences pendant les 6 semaines. Je voudrais simplement évoquer un deuxième aspect de la justice en France, parce qu'ici, je pense que c'est très mal compris au Rwanda, ce sont toutes les procédures concernant les extraditions. Et je me suis rendu compte que, aux réactions que j'entendais de la part des responsables, en particulier de la justice à une certaine époque, il ne faut pas confondre les magistrats qui sont chargés de décider les extraditions avec les juges d'instruction qui viennent au Rwanda et qui enquêtent. Les magistrats chargés de l'extradition, ce sont les cours d'appel. Certaines cours d'appel en France avaient donné des avis favorables aux extraditions. Et tout récemment, la Cour d'appel de Paris, qui pendant des années avait refusé les extraditions, avait changé de jurisprudence et avait finalement accepté de donner un avis favorable à l'extradition de 3 présumés génocidaires, dont Laurent Seloubuga, Claude Mouaïmana de Kibouye et Innocent Moussa Bimana, qui habite la région de Dijon en France. Or, c'est la Cour de cassation en France qui systématiquement casse les décisions des cours d'appel quand elles sont favorables. L'argument, pendant longtemps, c'était au Rwanda, ils n'auront pas de procès équitable. Bien évidemment, nous contestions cette décision, mais actuellement, la raison essentielle pour laquelle ils insistent et ils refusent l'extradition, ils font appel à ce qu'on appelle la légalité des peines et des délits, et en particulier le principe de la non-rétroactivité des peines. Dans la mesure où, en 1994, la peine, il n'existait pas de peine au Rwanda, c'est-à-dire que la loi organique punissant le génocide est postérieure au génocide lui-même, et donc les magistrats de la Cour de cassation estiment que, au nom du principe de la non-rétroactivité, on ne peut pas juger, on ne peut pas envoyer au Rwanda des présumés génocidaires pour y être jugés. Il n'y avait pas de peine prévue dans la loi. Or, personnellement, je vous l'ai dit tout à l'heure, je ne suis pas du tout, mais pas du tout juriste. Mais il faut savoir quand même qu'il y a une exception dans ce principe de la non-rétroactivité, c'est celui pour des crimes de génocide. Comment la France s'y est pris pour juger en particulier Maurice Papon ou Touvier, qui pendant la Seconde Guerre mondiale avaient participé aux crimes aux côtés des nazis. Donc c'est une position qui ne tient pas, mais la Cour de cassation n'a pas voulu changer de jurisprudence contrairement au TPIR ou à d'autres pays. Donc j'insiste beaucoup, je comprends votre irritation qui est la nôtre lorsque les magistrats de la Cour de cassation refusent d'extrader, mais s'il vous plaît, ne condamnez pas les juges d'instruction qui viennent ici en commission rogatoire, parce que sans eux, il ne pourrait pas y avoir de procès. Au contraire, quand les juges d'instruction viennent avec les gendarmes français, malgré tous les ressentiments qu'on peut avoir contre la France et le gouvernement français de 1994, j'insiste bien, ce n'est pas la France, parce que ce sont les responsables politiques de 1994 qui sont intervenus au Rwanda en notre nom, mais nous n'avons pas été consultés. Je dis bien, c'est le gouvernement français de 1994. Donc s'il vous plaît, accueillons les juges d'instruction, aidons-les dans leur travail. Sans eux, il ne pourrait pas y avoir de procès en France.
Monsieur Gautier.
En conclusion, je savais que 10 minutes c'était trop court. En conclusion, ce procès de Pascal Sibikongo a été très difficile, je vous l'ai dit. Mais nous espérons maintenant que si vous voulez, nous avons tiré une formidable expérience de ce procès. Nous sommes beaucoup plus riches maintenant pour pouvoir affronter les autres procès qui vont venir. Je voudrais lancer 2 appels. Un d'abord, je dirais des appels à témoins. On s'est rendu compte que les témoins, c'est quelque chose de capital. Or, ici au Rwanda, il y a des gens qui savent, il y a des gens qui ont vu. Et dans les prochains procès, il faudrait absolument que les témoins, les gens qui savent, n'aient pas peur de témoigner. Il ne faut pas avoir peur, ce n'est pas à nous de baisser les yeux, ce n'est pas à nous de raser les murs, contrairement à ce que nos adversaires en France cherchent à faire. Ils nous insultent, ils nous traînent dans la boue, ils nous menacent même de justice parce qu'ils prétendent que, en particulier, nous les Gautier, nous gagnons des sommes d'argent formidables que nous ne déclarons pas au fisc. Donc, n'ayons pas peur, il faut que les témoins parlent et s'expriment. Et enfin, je voudrais lancer un appel, mais là, c'est peut-être un peu maladroit de ma part, mais nous sommes une toute petite association, le collectif des parties civiles. Nous sommes une association qui fonctionnons pratiquement sans moyens. Nous sommes 200 adhérents, mais 200 adhérents qui payent leur cotisation de 20 € par an. Donc ce sont des moyens dérisoires. Et à plusieurs reprises, nous avons lancé des appels à aide financière, ne serait-ce que déjà pour aider nos avocats à travailler et aussi pour que notre association puisse continuer à venir au Rwanda rechercher des témoignages, parce que sans eux, nous ne pourrons pas continuer ce travail de justice. Voilà, c'était simplement de ma part un simple témoignage, je dirais, d'un simple citoyen. Nous estimons que la justice est un chemin, et un des chemins, mais un chemin indispensable vers la reconstruction du Rwanda. Je vous remercie.
Merci beaucoup, Monsieur Gautier. I was asked to give a short summary of what was said in French, and I'm way out of my league now, but I will try. The first point I think to underline is that the speaker is wanting to let everyone know that these were crimes perpetrated in Rwanda, and to the degree that there's reluctance to prosecute these cases in the French courts, this is a consequence of the government and those who are not sympathetic, but certainly not of the French people as a whole. He's talked about the various cases that are in progress and the role of the partie civile in finding documents and also finding witnesses, and to say that it's a very small organization working on limited funds, but tracking even personal attendance of Mr. Gautier at these trials that are going on in France. Mention also 2 cases that were transferred by the ICTR to France for prosecutions in 2007, and those cases have not yet begun the trial process. He's hoping by 2016 that might be the case. And so with that said, we want to move on to some of the other individuals who are identified to make interventions to fill out the rest of the story about genocide justice. I want to call, first of all, on Jean de Dieu Muccio, who is the Executive Secretary of the Commission for the Fight Against Genocide, who will talk about the impact of justice in the various forms that we've heard about today, and what the survivors are thinking and feeling about, has justice been delivered from their point of view.
Thank you, Tim. Your Excellency, First Lady, Honorable President of the Senate, Honorable Speaker, distinguished guests, ladies and gentlemen. During the genocide perpetrated against the Tutsi, which took place from April to July in 1994, more than 1 million people were killed. The consequences that affected all sectors of lives include desolation, compromised unity and social cohesion, and all the country's key sectors were destroyed in justice sector, economy, health, education sector. Victims in Rwanda wanted accountability. They thought to see the perpetrators of the genocide brought to justice. The question here is, how was justice for victims possible after genocide? I will explore the role of national jurisdiction, International Criminal Tribunal for Rwanda, ICTR, and the other countries' court, the national effort for justice and reconciliation in providing justice for the victims of genocide against Tutsi. About the national jurisdiction, you know that the situation after the genocide against the Tutsi in 1994 was appalling. 1 million Rwandans died, more than 3 million refugees in the neighboring country, a big number of orphans and widows, more than 120 detainees accused of genocide crime, and the lack of law repressing genocide in Rwanda legislation. In order to ensure human rights preservation and justice, the post-genocide Rwanda government set up various legal instruments, which include the ordinary court, classic justice, and the Gacaca court that have their roots from the history of the nation, home ground solution. After genocide, there was no law, as I said, punishing the crime of genocide. It is after 2 years that the organic law was enacted. However, due to the large number of cases that were to be tried, it was found almost impossible for classic justice to be delivered in due time. This would not help either the genocide survivors or the perpetrators, since they all need justice. After the genocide, there was fear and the lack of trust between genocide survivors and the perpetrators. Genocide survivors lived life characterized by desolation, trauma, and fresh wounds, which caused many to even not participate in the judicial proceedings. Therefore, there was a need for an alternative system which would combine justice and reconciliation at the same time. And that is how the Gacaca court system came into existence. In introducing Gacaca, the government of Rwanda sought to promote justice, social harmony, and reconciliation. Some challenges that Gacaca brought to genocide survivors were persistence of insecurity for survivors of genocide, mainly caused by relatives and the friends of convicts of genocide who wanted to revenge or to silence the witnesses. Another challenge is the desire to address the issue of reparation for genocide survivors. Some perpetrators who were convicted of complicity in genocide were found unable to provide reparation to those whom the crimes were committed. All the above and more other challenges, however, have been addressed by the government in collaboration with the civil society, especially survivors associations, the private sector, international community, and the Friends of Rwanda. For the international justice, in a general sense, the ICTR was set up to contribute to this process of national reconciliation in Rwanda by prosecuting the masterminding and architects of genocide. Some countries like Belgium, Switzerland, Canada, France, UK, USA, and in other countries have investigated and prosecuted genocide suspects found on the territories, an action that has placed the victims of genocide, thus a large number of perpetrators is still at large. Concerning the international justice, witnesses from Rwanda, mainly genocide survivors, have met challenges in the procedures used in the judicial system that they are not accustomed to. Also, as mentioned earlier, witnesses face security issues, mainly intimidation by a relative of the accused. The post-genocide government of Rwanda has set up also various mechanisms and organs to address and handle issue of genocide and its consequences. There are some include the Constitution of 2003, the National Commission for the Fight Against Genocide, CNLG, the Fund for the Support and Assistance to the Survivors, FARG, the Office of the Ombudsman, and the National Commission for Human Rights, the National Unity and Reconciliation Commission, and other institutions. To conclude, certainly justice for the crimes of the genocide can never be fully realized. Justice could only ever be a partial response to the crime. There are no adequate or appropriate remedies for crime of genocide. It is generally agreed that the UN failed to victims of the genocide. Instead of the protecting civilians, the UN military contingent fled the country during the peak of the killings. And I think the 20th commemoration of the genocide against Tutsi is an opportunity for the international community to address the issue of repression and call for an explicit form of support to survivors. Thank you.
We're going to depart just a little bit. We have two other respondents, but because of the issues that are on the floor, issues of effectiveness of justice, bias of judges, lack of reparations, I'm going to pause now and allow those of you with relevant questions to ask a question, and please do that because of the time we have remaining, to ask a question based on what has been introduced so far, and we'll come back to our other respondents. Okay, if you're interested in asking the question, please. And while they're doing that, I'm going to ask Dr. Gordon to come forward. He'll make remarks about the international component of justice, and we have also Hushtakai Sezi, who has been sitting very patiently, will make remarks about the gender component of justice. No questions at the moment on what has been introduced. Yeah, I see a hand way in the back there. Oh, they're not ready yet with the microphone, so let's take Dr. Gordon's introduction, and then we'll come back once they have the microphones there.
Thank you. Your Excellency, Madam First Lady, President of the Senate, Speaker of the House, honorable state representatives and guests, thank you to the conference organizers. It's a great honor to be here. Our topic today is how effective is justice after genocide? And I think it's important for purposes of this solemn occasion to take an expansive view of the word justice. With an event as cataclysmic as the genocide against the Tutsi in this country in 1994, I think that makes sense. The murder of nearly 1 million innocent persons in just 100 days, less than 1/3 of a year, is hard to imagine. What can justice mean in such circumstances? I think It is, in fact, multifaceted, this concept of justice. On one hand, justice is vertical. What do I mean by that? Well, I think we can imagine a hierarchy of legal sources starting with international law. And at that level, we have the International Criminal Tribunal for Rwanda. The ICTR has brought to justice the leaders of the genocide, the architects, those who planned, organized, and supervised the killing from the national to the local level. Many have criticized the ICTR for only prosecuting fewer than 100 persons in nearly 20 years, but it has operated within its mandate of prosecuting the big fish. And it has made extremely valuable contributions to international criminal law. For example, establishing that widespread and systematic rape can constitute a form of genocide, and establishing the elements of what I call atrocity speech law, such as direct and public incitement to commit genocide, and hate speech as the crime against humanity of persecution. Also, somewhat international have been the universal jurisdiction prosecutions of Rwandan genocidaires in domestic courts around the world. And we have seen convictions in countries such as Belgium, Canada, Switzerland, and Germany, and the Netherlands. Even France, as we just heard, most recently had its first conviction of a Rwandan genocidaire. At the national level, in Rwanda, there have been trials in both the conventional courts. Approximately 10,000 people have been tried. Rwandan domestic law, known as the organic law, brilliantly divided suspects into 4 categories. Category 1 includes the leaders of the genocide. Category 2 includes people who killed or intended to kill under the orders of others. Category 3 includes those who caused serious bodily injury, while Category 4 includes individuals who committed property crimes. I looked up some statistics, and from 1997 through 2002, for example, 7,211 persons were tried, of whom 1,386 were acquitted. The rate of acquittal actually rose from 22% in 2001 to 27% in 2002. And then, of course, there was Gacaca. And in the Gacaca courts, Rwanda has done something nearly miraculous: adapt a local justice mechanism for genocide and provide truth and reconciliation at the local level. In just 10 years, approximately 2 million people were tried. And this was not just rubber stamp justice. Approximately 65% of those tried were found guilty, meaning that about 35% were exonerated. This was a brilliant way to render justice with respect to so many in such a short amount of time. Justice has also been horizontal, and what do I mean by that? Here I'm talking about justice over time. We saw this after the Holocaust. At first, there was a large focus on international justice with the Nuremberg trials of the major Nazi war criminals. But after that, there were zonal trials of lesser criminals in each of the occupation zones. And then there was a period of many trials in Germany in the 1960s and 1970s. Today, as the biological statute of limitations is running out, Germany is still bringing to justice the last of the Nazi war criminals before they can completely escape justice through death. And in Rwanda, soon after the genocide, the ICTR was the focus of justice efforts. But now the ICTR is wrapping up, and it is transferring suspects to Rwanda for trial. And now, as in Germany after the Holocaust, it would seem the main focus of Rwandan genocide trials will be here in Rwanda. I worked in the Office of Special Investigations with the US Department of Justice, and we tried many Nazi war criminals in the US many decades after these criminals committed their crimes. Our philosophy was that their evil deeds were frozen in time, and the passage of years changed nothing in terms of the need to bring them to justice. I hope that is true of Rwandan genocide suspects too. They should be pursued until the biological statute of limitations runs out. They should never feel as though they have escaped justice. Justice will find them. Has justice been completely effective? No. Certain acquittals at the ICTR are very shocking and disappointing, including the recent acquittals of Justin Mugenzi and Prosper Mugiraneza, as well as earlier acquittals such as that of Prote Zigiran Urazo. But still, the ICTR has convicted over 80% of its defendants. Its justice has often been inefficient and slow, but it was an ad hoc tribunal that had to start from scratch. I know, I was here at the beginning and saw how difficult it was. Hopefully, it has taught the world certain important lessons in terms of what to avoid in future such justice enterprises. Justice has also been delayed. I have followed closely, for example, the case of Leon Mugesera. It seemed to take forever for his case to work its way through the Canadian courts, but at last he was extradited, and now he is finally on trial here in Rwanda. 6 of the top genocide suspects are still at large. For me, Felicien Kabuga is particularly a troubling case. I worked on his case when I was at the ICTR. He was a main financier of the genocide and founder and financier of Radio Mille Collines. But I am optimistic, and I truly feel he will eventually be brought to justice. Again, justice proceeds horizontally too. And even for those who may escape trial, justice is also about memory. And it is for us and future generations to make sure that these crimes remain in the minds of all humanity, that we collect archives and testimonies, that we make them available for the public. Let us never forget who the criminals were, and let us always honor the memory of the victims. Finally, justice is poetic. I remember arriving here in Rwanda not long after the genocide. I remember seeing a country that was still in shock, still in trauma. One could see the signs of mass murder and horror. And now I think of my feeling arriving here last night. As I made my way from the airport to the hotel, I saw a city that was alive and buzzing with energy and optimism. This was the spirit of life, and this was poetic justice because it meant that the Tutsi people had overcome the genocide, that the Tutsi people was moving on and thriving, preserving the memory of the victims, honoring the memory of the victims, but moving on and thriving all the same. And this kind of justice seems to me the most satisfying justice of all. God bless you all, and may you continue to thrive and prosper while never forgetting.
Thank you, Dr. Gordon, for your intervention. As they're still working on the microphones, I believe we'll take now discussion response from Dr. Usta Kaitezi, who is the principal of the College of Arts and Sciences at University of Rwanda.
Thank you, Tim. Your Excellency, the First Lady of Rwanda. Excellency is here, all protocols observed. It's an honor for me to bring to this discussion how effective was justice, was post-genocide justice, and I will bring into your attention the role of what justice has done vis-a-vis gender-based crimes. It's already been mentioned that gender-based crimes were a very big, important element of the genocide, and therefore any justice system would have as well been important and effective if it considered that. I will also limit myself only on the Gacaca courts because for me they were the biggest contributor in this perspective. The Gacaca courts dealt with the biggest number of gender-based crimes, but they did not deal with them only. They considered a victim-friendly environment to that effect. And therefore, I think the discussion should be, how has Gacaca courts addressed gender-based crimes, and how that has impacted the reconstruction of the victims themselves. I have argued that victims had a say in this court system, and they were able to do justice as well, but also to see justice done for them, for the victimization that has happened on them. It's important that we look at one of the elements that the Gacaca courts addressed, which was broadening the victims, as indeed they were. It did not limit itself on the victims of gender-based crimes as only women. even though they were the majority, but it also took an aspect of some men, some Tutsi men who were victims of gender and sexual violence. And that captures the social deconstruction of genocide in its aspect. And therefore, the Gacaca courts as a system, I would raise a discussion to how effective they have been able to do this and bring this to the platform of justice. My other point of reference is the punishment and their role to reconstruction. I think for Rwandans, and I think should have been for the world, justice should also have been seen strongly on its role in the reconstruction of the Rwandan community. And I see justice in the Gacaca courts and in the other aspects as one of the tools that we are leading us into our reconstruction system. And on that basis, I want you to reconsider or to discuss on the role of punishments that were involved in these systems. I'll give just one example. When Gacaca courts introduced for the very first time community service for public interest as a punishment, there was a discussion that that was undermining the genocide. But on the other side of it, and I would strongly argue that it was a means of reconstructing the society. Because as these people do the community service, they are also going back to the society, giving back to society, but reintegrating in the society and interacting with the society. When that is measured against the trends we see for the people who have been convicted at the ICTR, the residue mechanism very busy looking for where they are going to be accepted. It brings a challenge to what justice has done and what international justice has done. If people have gone through the system, they have served their penalty or have been found guilty, why then do we have a system of justice that has further excluded them from the community that they belong to? So it's very important that we reconsider the impact and influence of international justice on the reconstruction of society and the reconstruction of the perpetrators themselves. I would also like to bring, and this is my final argument, I would like to bring to your attention the trends of investigations, the trends of what the record has. For me, justice is also a narrative. And when we consider the legacy of the ICTR and the legacy of the Gacaca courts, a narrative has been established. It's very important that we unpack that narrative to see how much of that narrative covers the realities of Rwanda, but also covers the reconstruction and reconciliation purposes that justice should have, that post-genocide justice was intended and should have served. Thank you.
As usual, justice is unsatisfying, and I'm sure you're feeling very unsatisfied now by the inability of everyone who has something to say, important to say, to be able to do it. And I'm very sensitive to that because, as we've heard by a number of speakers, the main beneficiary of justice has sometimes felt left out of the process. Now, I'm told that there are microphones at each desk except for the very extreme, so if you will press the button when you are recognized, you can ask your question. And we've seen some hands way in the back over there, but I also want to put on notice two individuals because we have a lot of expertise in the room, including the prosecutor of the ICTR and Barbara Mulvaney, who was the lead trial attorney in the case against Bagasora et al., that they may prepare to make some commentary. And also the president of the ICTR, if he would like to make some response to remarks that have been made so far today, we'll give you that chance. So I see a hand way in the back. Whoever's got the mic, please ask your question.
I have the mic. Yes, I'm Sheikh Saleh Habimana, Member of Parliament, Chamber of Deputies. Praying and thanking the presenters. My question goes immediately to the ICTR president. I have followed him carefully just because the Rwandan people will look at ICTR as the sole provider of justice. Even though no justice can heal the wounds of genocide against the Tutsi. No justice can give dignity to children born through mass rape. The question I have to Mr. President, you have mentioned several times the word justice, ending by it. Yes, there was some highlights on destruction of Tutsi group. Now the question in one word, Mr. President, was it genocide or genocide against the Tutsis? Thank you, Mr. President.
Hello? Thank you. Thank you for that question. In all the findings in our judgments when we have been dealing with genocide, we have stated that the genocide was committed against Tutsis. There were other killings being committed during the 100 dark days, as I said, but they were committed against groups that would not qualify under the definition of the genocide concept. I understand that there's a sort of controversy concerning what to call what happened in Rwanda at that time. The Security Council Security Council decided to use the term genocide in Rwanda in a more general term than the technical term that we use in our trial judgment, namely to cover all atrocities that were committed in connection with the genocide against the Tutsis. And I know that the Rwandan government has raised this issue in New York, and if any new signals are being given from New York, of course we will also review the terms that we use to characterize what happened in Rwanda. That was the first question, but Tim, you also said I could comment on things that were said before about the ICTR, and of course what Andrew said sort of upset me to some extent. I didn't write down everything, but the first thing was that the ICTR was set up to assuage the guilt of the USA. It may be that a number of countries felt guilt for not intervening in Rwanda in 1994, but the initiative to set up the ICTR was actually Rwanda. Rwanda was then a member of the Security Council and requested the Security Council to set up an international tribunal in line with the ICTY, which the Security Council has set up the year before. It's true that Rwanda eventually voted against the resolution setting up the tribunal because they disagreed with the limited mandate we got with the seat of the tribunal, and also the issue of the death penalty. But the initiative came from Rwanda, and I think I addressed that issue in my opening remarks. I'm not going to comment on specific judgments. We judges have the principle that the reasons we have for our decisions we put in the judgments, and then we step back and leave the floor to others to discuss them. But I can say generally, as also Professor Gordon mentioned, that our acquittal rate is between 18 and 19%, as compared to the figure that Gordon gave me for the Gacaca court, which is 35%. And also that we are prosecuting as a special category of suspects, namely the people at the highest level. They don't leave a smoking gun behind them. In our cases, there's very little documentary evidence, so we have to rely on oral evidence. And further, very often we have to decide whether circumstantial evidence is sufficient to convict. And there are pretty high standards for convicting on circumstantial evidence. I don't want to take all of the time, but Andrew also mentioned financial irregularities at the ICTR. This happened until 1997, when we were about 1 or 2 years into our operations, and was investigated by our oversight committee, and since there's been no major issues of that kind with the tribunal. Finally, with respect to Harhoff and Judge Meron, I'm not going to comment on this. This concerns the ICTY, but just mention that Harhoff, as Andrew claimed, was never fired from the appeals chamber. First of all, because he was never a member of the appeals chamber. Harhoff was due to resign in October at the delivery of his large judgment in Session. Then Session challenged his impartiality in that case, which actually delayed Harhoff's departure from the ICTY. Thank you.
Okay, we asked Minister Bisingwe to make a clarification on a point that was raised already.
Thank you, Tim. Let me make 2 quick points before probably the debate proceeds to the legacy completely. I want to say that our legacy, the legacy of the genocide, is going through certain challenges. They have been talked about here, but I want to say that unless we address them, this legacy, I'm sure, will fall under question pretty soon. One, the President just raised an issue about what's going on at the appeals chamber. I think that it's worthwhile making some kind of discussion on whether the doctrine of superior responsibility is not under threat. We seem to think that it is getting under threat. 2, the incarceration Usta just raised here, when we worked with the ICTR and the international community to do an international incarceration place at Mpanga, we did not do it expecting to house convicts from any other place, although we are part of the international community, would have done that. But we thought Rwandan convicts would serve their sentences in Rwanda. That has not happened, and we are watching, and we do not know what happened. 3, what we call hate speech versus freedom of expression is getting very much attention, and the line in between gets thinner every day. Right here in Rwanda, outside there in Europe, the line gets thinner, and this debate seems to be tipping towards, there is nothing like hate speech, there is nothing like propagating a genocide ideology, but it's rather free speech, free expression. I think these are issues that a conference like this would want to take stock of and probably think deeply about. The responsibility to protect should also, in my view, include the responsibility to prevent another genocide. And that should include dealing with revisionism. Another quick point that I want to raise is the numbers that I have here, which are a little bit disturbing, from the Genocide Fugitives Tracking Unit of our prosecution department. We have 193 indictments lying out there, 26 in France, 17 in Belgium, 15 in the Netherlands, 5 in the UK, 6 Canada, USA 11, Norway 3, Sweden 2, Germany 2, Denmark. We have a whole shopping list here: Finland, Italy, Swiss, New Zealand, Uganda, DRC, Mozambique, Zambia, Malawi, Tanzania, Congo Brazzaville, Kenya, Gabon, South Africa, Swaziland, Burundi, Central African Republic, Ghana, Ivory Coast, Zimbabwe. Now, this is from A to Z of this world. Where are we? Those of us who are seated here, those of us who are not here. Among the countries that I have listed, some have taken up the mantle of dealing with this issue, and people are being tried. But there are other places where there is silence, either 3/4 silence and probably 1/4 of seemingly some bit of audible voices. In other places, we have got gentlemen like Alan Gautier, whom I would really request you people here to give a vote of thanks. During the genocide, we had people in Rwanda here who stood up and tried to defend. They were very weak, they did not have resources, but they protected people and made them survive. I have just a name called Zura Karihimbi, whom I always remember, plus a number of other people. Today, we are starting to see the likes of Alan Gautier out there in the world. Where are the other friends out there in the world? Can we stand up and work like he is working and get these people? If we read this list from A to Z, I do not think that it has nothing to do with the legacy. If we have a legacy like this with people out there, I think it will be half a legacy. We will be half successful. And as Dr. Gordon raised it, genocide is not a crime that is about to have a prescription. The biological time frame will kick, but we will not relent. We will continue searching, but we want more Alans, we want more Zuras, we want more people to stand up and look out for these people. Let them go to court. Let them go to court. We have offered that, please, if you don't want to bring them to Rwanda, if you think Businje is not going to try them fairly, try them yourself. That's a clear offer. Why don't we see this being done? This is probably a 10th conference or so. What do we do after these conferences? This is 20 years. We are starting to get worried. Let us have a coalition of friends to do something, not only here, but especially out there. I thank you.
Thank you, Minister, for those remarks. As a reminder, there will be, at the end of this three-day forum, some kind of a summary of what's happened, including an action agenda for moving along on some of the recommendations and suggestions that comes out of the deliberations. I understand that Mr. Gautier wants to make a short intervention, and then we'll call on the other individuals identified in the audience.
Oui, merci. Je voudrais d'abord m'assurer que j'ai bien compris la question. Il s'agit bien de l'appellation génocide des Tutsis ou génocide tout court. C'est ça? Au Rwanda. Oui, ou génocide au Rwanda. Alors, pour vous éclairer, si vous voulez, je peux en 30 secondes vous donner le réquisitoire de l'avocat général en France dans le procès Simbi-Kongwa. Il a bien distingué, dans sa demande de condamnation, de condamner Simbi-Kongwa pour crime crime de génocide, et il s'agissait bien du génocide des Tutsis. Mais il a demandé aussi de condamner Simbi Kangwa pour complicité de crimes contre l'humanité, et il a expliqué que dans cette appellation, il entendait faire condamner Simbi Kangwa pour toutes les autres victimes de cette période 1994. Donc, vous voyez bien que on doit se battre, je pense, pour appliquer l'appellation crime de génocide des Tutsis au Rwanda, mais ça n'empêche d'évoquer aussi les crimes contre l'humanité et tous les autres crimes commis, et je pense qu'il n'y a pas d'honneur spécial à être victime d'un crime de génocide ou d'un crime contre l'humanité. Le crime de génocide est un crime contre l'humanité. Je le dis comme je le ressens, je ne suis spécialiste de rien du tout, mais voilà comment, si vous voulez, la décision en France peut peut-être éclairer la question que vous avez posée.
Thank you, Mr. Gautier, for your intervention. This time we're going to call on the prosecutor of the ICTR. We know that judges who sit on the bench are prohibited from making commentary on decisions and the reasonings for it, but I'm sure that the prosecutor is not so bound and may want to say something about the appeals process and the latest acquittals.
Thank you, Tim. I just have a few points which I'd want to make. The first point is that international criminal justice has its deficiencies. It has its difficulties, like every legal system. But it is a system that is absolutely necessary. Why? Because it can reach people which national systems cannot or will not reach. And in practical terms, we can see this demonstrated in respect of the Rwandan situation. All the people that the ICTR indicted had left Rwanda after the genocide in 1994. And it wasn't until a year or so ago that any country was willing to extradite anybody to Rwanda to stand trial for those offenses. So in effect, that meant without the intervention of international criminal justice in the form of the ICTR, those people forming the leadership which planned and executed the genocide would not have been brought to account. I think we have to recognize this fact, the importance of international criminal justice and the contribution of the ICTR also in this respect. In addition to that, of course, we do recognize that national jurisdictions have the primary responsibility to deal with these kinds of offenses. And that is why, even towards the end of our lifetime, we have been referring cases to Rwanda for trial. We've already sent the cases of 8 indictees to Rwanda, 2 of them in person who are here standing trial. And prosecutor to prosecutor, I have handed over some 56 case files to the Prosecutor General of Rwanda for him to follow up and prosecute. So it's not all a kind of minus on our balance sheet. Then I think we also need to recognize 2 other areas where the ICTR has made a tremendous contribution to Rwanda. One is this: in the declaration of the genocide, in the decision, of the appeals chamber of the ICTR in 2006, in the case of Karamera, to take judicial notice of the occurrence of the genocide. The court decided that the occurrence of the genocide is a fact of history which does not require any proof. And that really is helping close the door to denial and revisionism, because this is the highest international judicial recognition of the occurrence of the genocide, meaning that no further proof is required of the occurrence of that tragedy. And that is part of the ICTR effort in blocking denial and revisionism. Beyond that, too, I think the decision of the appeals chamber of the ICTR to refer the cases to Rwanda for trial, because it found that the Rwandan legal system is both competent, efficient, and provides possibilities of fair trial, is the highest international judicial recognition that the tribunal has given to the legal system of Rwanda. That has had the effect of opening the doors for many other countries to extradite cases to Rwanda. And I think it has had other effects as well, even in the area of reconstruction. In relation to the cases themselves, I think we also need to recognize that, difficult as they are, because we prosecuted mostly people in leadership positions, we indicted some 93 people, we arrested everybody except 9. The number of people who were prosecuted to conclusion so far is 75. And of those 75, we secured convictions in respect of 61 of them, 13 of whom were convicted for offenses of sexual violence. That's a very high conviction rate. And I think credit must go to the ICTR for that as well. There have been some acquittals, yes, of some senior people, but the acquittal rate, and as I said, the conviction rate rather, has been quite high in the ICTR itself. Prosecuting senior people, of course, is a difficult and challenging fact. There are difficulties with gathering evidence. There are security issues for potential witnesses and people who want to collaborate with the Office of the Prosecutor. Senior people are not the ones you find in the barricades. They give their orders and they give whatever they do is behind closed doors. And so accessing the evidence becomes extremely difficult. Nonetheless, the Office of the Prosecutor, contrary to I think what my friend Andrew Willis had said, has not fallen below the level expected of it in the discharge of its responsibilities. We've gone out of our way to provide security to people and their families whose evidence was crucial in the prosecution of senior people. And I think it's important to remember also that in relation to most of these acquittals, initially, actually, there had been convictions. That was a success by the prosecution. First, in securing judicial approval for the issue of an indictment, because the judge's decision for the issue of an indictment is based on their satisfaction with the evidence, that there is a prima facie case. The prosecution got over that hurdle, and in most of the cases of acquittals as well, we had actually secured convictions at the level of the trial, at the level of the trial chamber. Some of them were reversed subsequently, largely because the appeals chamber felt the trial chambers had made errors of law or errors in the appreciation of the evidence. But the prosecution had discharged its responsibility and indeed secured convictions in most of the cases relating to senior persons. Those are just the comments I wish to make. Thank you very much, Tim.
Thank you, Prosecutor Jallow. As the moderator on the time that has been long since expired, I'm going to use my prerogative to raise an issue that I think will advance the debate and get to some of the things underlying my insistence on having this issue of the appeals chambers acquittals addressed. There is a legacy that's being developed, and the acquittals of very high-level perpetrators at the appeals chamber level suggest to many observers of the court and students of the law that there is a certain activism that may be existing in the appeals chamber. And by that I mean those individuals who have been acquitted of conspiracy to commit genocide. It is now fashionable for individuals who would like to rewrite history and to minimize genocide and to actually engage in genocide denial, to say that the consequence of those convictions and the overturning of those convictions by the appeals chamber really means that there was no planning of the genocide. There was no master plan for the slaughter to take place. And those of us who are students of the law and concerned about justice and the legacy of the tribunal are quite troubled by that development in the appeals chamber. And I say this as someone who has read those decisions, including the dissenting opinions about those decisions, that is open to debate for the larger issue of justice in this society and holding people to account for genocide and crimes against humanity. And I know the prosecutor is got a certain discretion to say or not say, and I know that Barbara Mulvaney, who was the lead trial attorney in the Bagasura case, would like to speak on this issue because she's doing some research on these acquittals. Now, the last point that I'll raise is that about a curious jurisprudence that has been developed in in the appeals chamber that allows genocide perpetrators to collect financial compensation for moral damages and for violations of their rights to defense attorneys paid by the ICTR. And they have found that in several cases that the justice says on the appeals chamber said these people are not only entitled to compensation, but they were ordered to be paid compensation. In the case of Ramakuba and in the last couple of acquittals, in the dissenting opinion, the judges found that had they made the case for lost wages, that a compensation of $5,000 would be in order. So it raises some unease about what is going on at the appeals chamber level for these broader issues of justice that are hinging on these cases that have been overturned. Now that's all in the context of where the appeals chamber has not found that the tribunal has authority to grant compensation to the very victims that the tribunal was set up to exonerate and to give justice to, because there is no provision for the tribunal statutorily or economically to give compensation. But we find the appeals chamber has created this doctrine that the perpetrators, especially those acquitted, are entitled to financial compensation without budgetary concern about where it will come from. So I want to raise that, and maybe, as you said, those who read the decisions can go on with the discussion about what it means for international justice and certainly for those survivors and family members who lost their loved ones back in 1994. That's my intervention and my prerogative, and if Barbara Mulvaney is here, she can take the stand. Barbara, are you here? Yes, please.
It's my profound honor. Can you hear me? No? I have a new one now. It is my profound honor to be here. Really what I want to do is to tell you a woman's story. And the reason I want to do it this way is that it's been my training as a prosecutor. We don't criticize judges. We don't criticize the system. When a verdict is given, we stand up and we say, the system has spoken. But in this situation, it's not adequate. And I want to tell you about a woman's story because in the Bagasora case, which I led for 6 years, I was in trial, actually, I was in the courtroom for over 400 days. A large part of it that I was very passionate about was the sexual violence that we saw during the genocide. When I arrived in Arusha 6 weeks before the trial, I realized there was no sexual violence expert and the whole investigation of sexual violence had been neglected. What I did is I went ahead and I got a sexual violence expert, Banaifer Noroji, who was teaching human rights at Harvard, and I asked her to come on board as our advisor. What I did is refashion the whole case, and I asked every witness that came on the stand to talk about sexual violence from their perspective, from what they saw, whether they were a paracommando, whether they were a person in the field, anything that they saw about sexual violence, I wanted to hear about it. And I cut all of the victims of sexual violence. It was very controversial, but it had to be done. None of the perpetrators in our courtroom raped anyone that we knew of. They were not charged with that. They were charged with command responsibility. So what I had to show is that they knew or should have known that rapes were going on, which is why we incorporated it into everyone's testimony. What I'd like to do is to go through just really briefly how the justice said, classic justice is inadequate for what we faced in the courtroom. I was limited to 100 witnesses for 800,000 people who had died, the death of all the political opposition, the training of the militia, a 4-year fact pattern. It was absolutely inadequate. And so what you see is classical justice, which is set up for a homicide that took place in 1 hour, and you have 10 witnesses. So we had a whole different situation. So what we did is we lost one battle after another fighting with our trial chamber to get the sexual violence experts' testimony admitted, but we won. We won along the way. We won incremental justice. And I was very When I read a verdict, I go to what I care about the most, and I looked at the rape count. I said, from the trial court judges, we got the rape count. When I looked at it closer, yes, we got the rape count, but they narrowed down Bagasora's overall responsibility to a very small portion, as Tim had talked about, you know, sort of getting rid of the conspiracy and other parts. So we had a very trimmed down rape, but we still had a rape count. Part of that rape count was the rape of Prime Minister Uwilingimana. She was raped with a Fanta bottle. I'm sorry. When it got to the Court of Appeals, that was overturned. And it was overturned in a way that, to me, is symbolic of the way that classical justice is inadequate. To me, it was symbolic of everything that happened to women. I'm a little too emotional. I'm humbled to be here, and I thank you.
Well, on that very last precinct point, I think we have to close our session. The debate is not done. It is just beginning. We're starting now to touch some of the real important, sensitive issues, and I hope indeed that you will continue the conversation over lunch and in other forums as we discuss and try to come to grips with this issue of, is it possible to have justice after genocide? Thank you for your attention.